My name is Katharine Young. I'm a professor at Boston College Law School, and I research and write in the area of economic and social rights. So I recently published a book, Constituting Economic and Social Rights, with Oxford University Press.
Congratulations.
Thank you.
May I ask you how you perceive the relationship in general between the economic crisis and the protection of human rights?
Yes, so the economic crisis has certainly had a massive social impact, and the human rights framework gives us a way of understanding whether that impact has actually impacted on human rights. Of course, in the human rights law, we have doctrines available to understand whether there is a state of emergency at play in which human rights may be legitimately suspended. We can provide that kind of analysis to understand what's going on in a kind of fiscal crisis, but there are kind of baselines to meet in terms of how human rights are respected even during states of emergency. What kind of infringements might be necessary? Who is experiencing the impact of human rights infringements the greatest? Those kinds of questions do lead to the suggestion that because those experiencing income and wealth distributions at the middle or the bottom half of society are experiencing the burden of austerity the greatest, then we might actually ask whether that burden they're experiencing is proportionate and whether that's justified. And the human rights framework gives us an analysis that suggests that austerity as a measure to respond to the fiscal crisis may not be justified in that framework.
Thank you very much. And I've seen from your publications that you have been studying notably the question of the judicial review and whether it can play a catalytic function in order to ensure the protection of human rights. May I ask you to develop this a bit and to present your main findings?
Sure. So I've been very interested in seeing how courts actually respond to human rights infringements and to economic and social rights infringements. Usually when courts are involved in judicial review of human rights violations, there's a kind of problematic pole between them usurping the political branches or abdicating their role. And they have to occupy this very difficult middle ground in the sense that they're not usurping the electoral branches, which are obviously have the greatest accountability to make socio-economic policy decisions, but equally they're not abdicating their role to uphold fundamental rights. And I think in the conditions of austerity, we're seeing that problem of abdication the greatest. It's the time in which the greatest pressures are on courts to respond to human rights violations. So I've been very interested in looking how courts around the world respond to this problematic tension between usurping the electoral branches and abdicating their role. And I think one function that has been very useful to understand is how they might catalyse the resolution of particular political disputes without stepping over their legitimate role in the separation of powers in which they occupy. So that leads to a number of particular questions that courts can ask themselves when they're faced with litigation and rights claiming in their jurisdiction. And I set out these questions in relation to what I've seen occurring in various jurisdictions, including in South Africa, in India, in Germany, in the United Kingdom, and in other places. And so the questions that courts need to ask of themselves are really much dependent on the legal tradition that they occupy, whether they're based in a civil law country or a common law country, and the traditional role conception that courts have in that jurisdiction. They also need to ask about their own legitimacy in making particular orders and how interventionist those remedies could be. They need to ask too what kind of rights are explicitly guaranteed in their jurisdiction. If it's a jurisdiction which has a Bill of Rights which tends towards protecting civil and political rights without explicitly articulating economic and social rights, courts can still ask themselves whether in interpreting civil and political rights, such as the right to life or the right to dignity, there is still a need to recognise the protection of fundamental material interests. So we see the Supreme Court in India, for example, very vibrantly reinforcing the link between the right to life and economic and social rights, and using that link then to kind of exercise judicial review over perceived infringements of the right to housing or the right to education or the right to food. And I think that's a very generative framework for courts to occupy to ensure that fundamental material interests, as experienced as economic and social rights, are not being infringed. What I've seen is that courts can give various methods of scrutinizing executive policy or legislation to ensure that rights are complied with. And if they find that they're not being complied with and those infringements are not justified according to particular standards of proportionality, as I've mentioned, or according to standards of reasonableness, which we see come out of the South African jurisprudence, or according to standards of the minimum core or the existential minimum or the vital minimum, which we see a lot of courts in Latin America upholding, or in Germany. So if courts find that that kind of minimum is not being met by legislation, they can actually step in to provide remedies. But these kinds of remedies don't have to be completely muscular or interventionist. They don't have to dictate then what the legislature has to do to respond to the problem. They can merely declare a state of infringement and then require the legislature in the space of a month or in the space of even a year to respond to the problem. This really relieves the pressure on the court of usurping the role of the elected branches. There are various other remedies that can be provided to ensure the democratic accountability of judicial processes. So I've seen courts in South Africa, for example, provide a remedy of meaningful engagement, in which affected parties are forced to come together to engage, to work out a resolution of a problem of a rights infringement. So that's kind of triggering a democratically accountable response to a rights infringement without involving the court in setting up what it would self-prescribe as the resolution, which we know courts are not technically competent to decide. So there's a range of techniques available in comparative jurisprudence. Courts in Europe are very good at generating a lot of comparative jurisprudence, and particularly in the EU, the European Court of Human Rights, for example, is a great source of comparative jurisprudence. But in my research, I see that such courts can also be receptors of jurisprudence. This is also a suggestion made for courts in the United States, which have generated a lot of comparative jurisprudence and are recommended to actually integrate the lessons from abroad now. And I think looking at various jurisdictions, the doctrinal avenues available, the kinds of remedies available, there's a lot of comparative jurisprudence out there that courts can borrow from in articulating their own standards and their own remedies.
Thank you very much. This was very interesting. Thank you.
You're welcome.